minutes, may I mention a matter?
Yes. Why
There's
didn't
a personal appearance matters and serial number 13.
you never mentioned it? Why didn't you mention it in the minutes?
Serial number
13 को क्या हुआ? किसने
not
personal appearance?
and the secretary of housing movement. We were not appearing. The lawyer was not
So
appearing.
he's supposed to assist us, no?
Yes, he's
You
not.
don't need to worry about it. He will wait. We have been waiting for him for his appearance for so many dates, isn't it? I remember.
Our name was not reflecting in the cause list minutes, and he had given us the wakalatnama. It will not be filed till 15 minutes. That was the only reason we could not appear.
Otherwise, you are ready.
Yes, minutes. We filed.
Counter is ready.
Yes, minutes. We filed our counter.
So you file your counter affidavit. Let him go. No problem. I'll pass an order to him. Yes, it's okay. Are you the secretary? What's your name? Okay. इनका appearance आप दे दीजिए. लिखिए. Serial number
13.
13. Who you are for the petitioner? Serial number 13. ठीक है. MS Surbi submits that on previous occasion she did not appear in the case as her name was not appearing in the list. Is that correct?
Yes.
As her name was not appearing in the list, the Secretary of the Jharkhand State Housing Board is present pursuant to the orders passed by this court. She submits that she is otherwise ready with the case and wants to file counter affidavit. And she also submits that a counter affidavit along with wakalatnama has already been filed. Considering the submissions, the appearance of the Secretary of Housing Board is dispensed with for the present. क्या stand लिया आपने?
Minutes. They are saying that the plot is encroached minutes. We are saying that we have already given the possession. They are taking the possession at that time.
Post possession it has been.
Minutes, even if there's any encroachment minutes, we'll give them that plot only minutes with the help of local administration.
That's all. Will you be happy with that?
We have always wanted the position. They are saying that we have already given the position and then we will.
कोई बात नहीं दोबारा पोजीशन देंगे आप. Right? हो जाएगा?
हो जाएगा.
हाँ चलिए. आपका चाहिए. हम लोग जब केस टेकअप होगा तब करेंगे. बैंक को घर दिलाइए ऐसे कैसे चलेगा? Right? Appearance memo दे. डेट पड़ेगा लेकिन अभी इतना ऑर्डर है जब केस टेकअप होगा तो आप रहिएगा काउंटर एफिडेविट मंगा लीजिए
fixed for tomorrow, but as per the information received from Mr. A.K. Sani, his flight has got delayed, Your Ladyship. So he has requested.
कल ही होगा आज नहीं होगा कल ही अर्जेंट होगा आज ऐसे ऑर्डर बीच में नहीं चेंज कर सकते कल आप आएंगे हम तो आपको बोले थे वो आएंगे जेट लैग होगा बहुत चीज़ होगा फॉरेन से आने में थोड़ा एक दिन टाइम लगता है ऐसे नो प्रॉब्लम वी विल एडजर्न अदर साइड भी तो थे ना इसमें other side was there in this case. We'll adjourn. ऐसे ऑर्डर चेंज करना थोड़ा मुश्किल है.
Item 8 CRP 642 of 2016.
We are at page 41. 2.2. 2.2 so and so quarrel took place between the party. Police were on the spot of the incident on so and so itself. Initiated proceedings under section so and so. On 29/16 an application under section 156 3 CRPC was filed by the complainant against so and so, accused so and so, and the uncle so and so as well as father so and so. And their three other brothers referring to incident between 19/7/16 at about 6 p.m. Allegation in the complaint was that two daughters of complainant so and so had gone to public platform outside the house, complained for fetching water. At that time, so and so accused indulged in incident gestures towards them, started pressing their so and so, the daughters so and so. It was further alleged on the same day, Honorable Haq, the accused and their brother, with common intention, possibly entered the house. The complainant heard filthy abuses and started beating the daughters inside the house. The application further alleged that applicant gave information about the incident, but neither application was taken nor what conducted. Application also sent in registered post to Supreme Police, so and so. New Delhi. In the application, offence alleged is that we were under section 323, 354, 506, 452 of the IPC and section 4 of the POCSO Act. On the application, miscellaneous case number so and so was rejected. The learned additional district judge also considered the application of the complainant and by order dated 14/10/2000 rejected the application, holding that there are no sufficient grounds to register the case against the applicants. The learned sessions have also noted that according to the report of the police station, proceeding under section so and so has been initiated as said is. The complainant filed a criminal division in the High Court. The High Court by judgment dated did not intervene the order rejecting the application. However, it observed application is an alternative in the party. Appropriate application concerned as well the producer. The application has having already been sent to so and so commission on the instruction of National Human Rights Commission. The student of police directed the complaint to be acquired by letter address to CO Jaunpur to inquire the complaint. CO City Jaunpur conducted the inquiry according to the statement. Various persons including Dr. the complaint, Firdaus Banu and so as well as the accused and submitted the report on 11/12/2016 finding that allegations leveled by the complaint did not be proved in the inquiry. The complainant thereafter filed complaint case number 1 of 2017 dated so and so reporting the same allegations and other accused which were made his application under 156 police CRPC. The learned session judge by order dated 19/12/2017 summoned the applicants under section so and so of the IPC and section 78 of POCSO Act. Applicant filed application number 482 of the CRPC in the High Court claim for proceeding proceeding the complaint case number so and so as well as summoning order. The application has been dismissed by the High Court by impugned judgment dated 21/18, reviewed against which the judgment this appeal has been filed. Then were the arguments. And
In this,
para 10 onwards, Lordship para 10 was Bhajan Lal case has been was referred to. Then para 11, 12, 13.
These are the judgments which are
Yes.
relied upon.
Yes. I'm not reading these whole.
No, not required.
Because one or two more judgments are directly on the point and latest ones I shall be citing. Then Manoj para 14 is a reference of Devendra Pamlos, para 8. Yeah, honorable.
Basically, they are following the principles of Bhajan Lal.
They say, yes, Bhajan Lal, and they say when it is abused, then Manoj para 14 it not 4 lines I may read. Judicial process should not be an instrument of oppression or needless harassment. Courts should be circumspect and judicious in exercising discretion, should take all relevant facts and circumstances into consideration before issuing process, lest it would be an instrument in the hands of the private complainant. Then Malas kindly straightway come to paragraph 23 and 24 of the judgment. Principles were the court has discussed. Para 23. In the facts of the present case, we are fully satisfied that present case is where criminal proceedings have been initiated by the complainant with an ulterior motive due to private and personal grudge. The High Court, although noticed the judgment of this court in the state of Haryana versus so and so in so and so, but did not examine the facts of the case as to whether the present is a case which falls in any of the categories of enumerated in Bhajan Lal. Present case clearly falls in category 7 of Bhajan Lal case, and the High Court failed to exercise jurisdiction under section 482 CRPC in quashing the criminal proceedings initiated by the complainant. In view of the foregoing discussion, we are of the view that in permitting criminal proceedings against the applicant shall be permitting a criminal proceeding which has been maliciously instituted with ulterior motives, permitting such criminal proceedings to go on is nothing but the abuse of the process of the court which needs to be interfered by the court. Now, the next judgment, Lordship kindly come to Page number 70. इसका फैक्ट पारा 6 से देखा है. Para 5 onwards. On 30th 10 2015, para page 75.
Yes.
Should I read some other paragraphs of the
Yes.
previous? On para page 75. On 30th 10 2015, the complainant filed an application under section 156(3) CRPC against all the three accused, alleging commission of offence under section 376D, 323 and 452 IPC. In the application, allegation was made against the accused on 22/10/15 at about 7:30 p.m. All three accused came to the house of the complainant. At that time, she was alone in the house. It was alleged that all the three accused started misbehaving with her. They beat her with stick, fist and kick. Thereafter, accused Vinay and Narendra raped her one by one while Sonu stood outside. When Sonu told them about the arrival of the complainant's husband, all the three accused fled her. It was further alleged that she went to the police station on the same day, but the police did not register a FIR. An order dated 3/11/2015 was passed by Additional Chief Magistrate so-and-so for registration investigation to police station concerned. On 6/11/2015, the first information report was registered being number so-and-so at police station so-and-so under section 376D, 323, 452 IPC against the accused. After registration, the case crime was investigated by investigating officer. The IO recorded the statement of the complainant, her husband and mother-in-law. The complainant in her statement repeated her allegations. It was further stated she went along with her husband to the police station, but report was not made. On the next day, she went to government hospital Moradabad with her husband for medical examination. Doctor conducted medical examination to external injuries but refused to her internal examination. The husband and father-in-law of the complainant also recorded statement. They stated that before they arrived at the house, the accused had already fled. The IO asked the complainant together. Now she is ready to get done medical examination. Again the complainant answered, no, now there is no benefit out of medical examination. Now I don't want to get my wife medical examination done as much time has elapsed. When the husband was also asked some questions to get his wife medically examined, the following answers were given by them. Well then, those details Lordship will get, this was a kind of case. Should I read further facts?
No, it's okay.
Well,
It's okay.
now what are the principles are, whereas at paragraph 22 to 30, Lordship will find the various judgments have been referred. I am skipping. Para 41 is important. Paras are written. I am not reading purposely. 22 to 30 will consume much time. Para 41 is important. Page 89. Inherent power given to the High Court under section 482 is with the purpose and object of advancement of justice. In case solemn process of court is sought to be abused by a person with some oblique motive, the court has to thwart the attempt at the very threshold. The court cannot permit a prosecution to go on if the case falls in one of the categories as illustratively enumerated by this court in the state of Haryana versus Punjab. Judicial process is a sole proceeding which cannot be allowed to be converted into an instrument of oppression or harassment. When there are materials to indicate that a criminal proceeding is manifestly intended with mala fide and proceeding is maliciously instituted with an ulterior motive, the High Court will not hesitate in exercise of its jurisdiction under section 482 CRPC to quash the proceedings under category 7 as enumerated in State of Haryana versus Bhajanlal, which is the following effect. 7 is when a criminal proceeding is manifestly attended with bona fide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Above category 7 is clearly attracting the person. So and so, so and so, so. Now, brothers, next judgment. Brothers, 7 is Rasmi Jain. Here, brothers, page 90, just 2-3 lines I am showing. Here a ground was taken that the appellant or the petitioner before the High Court could approach the
Continue.
पेज 92 अगर आएंगे बस रश्मि जैन एक ही प्रिंसिपल पे खाली वो है here मतलब the honorable high court had declined to quash the proceedings saying that the petitioner therein could take a chance for discharge, so the proceeding should go on. Whereas high court has declined to quash the proceedings initiated, page 92 I'm reading,
Yes.
initiated against the appellant on the ground that all the submissions relate to disputed question of fact which cannot be adjudicated upon by the court under section 482 CRPC. It is further observed that at this stage only prima facie case is to be seen in the light of the law laid down by the Supreme Court in number of judgments, the R.P. Kapoor versus so and so, P.P. Sharma and Jantu Pharmaceuticals Pearls, relying upon the aforesaid judgments, but without culling out the ratio of any of the aforesaid judgments. It has been observed by the High Court that defense of the accused cannot be considered at this stage. It has further observed that the applicants have got right to discharge under section 239, 245, 2 or 227, 228 of CRPC, as the case may be, through a proper application for the said purpose. Now this was said. Manoj, then para 6 lordship will see the facts. Here Manoj, a threatening to death was the allegation made. Para 6 to take the complaint out of the realm of purely civil dispute, it is maliciously alleged in the complaint that when respondent number 2 approached the applicant for payment, the applicant stated as follows: on so and so applicant met the accused in the market of so and asked for his balance amount, but the accused in presence of 2 other persons flatly refused to pay the same and threatened the applicant that if he ever asked for payment again, he will be killed. Manoj then killed. Killed and stated that only I have not paid to high and mighty people who are had to assert to money, and I have done so. But in our opinion, here this passage is important. In our opinion, the aforesaid amendments have been made only to force criminal liability on the applicant by converting a purely civil dispute into criminal liability alleged to have been committed by the applicant. The allegations are absurd and outlandish on the face of it. Firstly, the applicant is a lady, a widow who is not accompanied by anyone else at the time of the alleged occurrence. Secondly, she, though being a resident of Delhi, misbehaved with number of high and mighty parties and parties with whom she had earlier transacted business at Moradabad. In our opinion, these are allegations which on the face of it cannot be taken seriously by any reasonable person. The High Court so. Then Manoj, again, Manoj here also, relying upon the same principles, it was quashed. If Lordship sees Manoj, page 98, 2023 Manoj, 2 judges bench judgment, 2023 SCC on line 1582. Here also, Manoj, I am skipping. Here also the discharge was rejected, and against the order passed rejecting the discharge, the party had moved before the Supreme Court. And Honorable Supreme Court was not only exceeded beyond the prayer, but what this Honorable Supreme Court has said, that is in para 23, because in that case discharge was rejected, matter had been before Supreme Court had been against the order of rejection of discharge application. Page number 108. Para 23. Para 23 लिखा हुआ है। On a careful conspectus of the legal spectrum, juxtaposed with our view on the facts and merits expressed here above, we are satisfied that there is no suspicion, much less strong or grave suspicion, that the applicants are guilty of the offence alleged. It would be unjustified to make the applicants face a full-fledged criminal trial in this matter. In an appeal dealing with the refusal of the High Court to quash a FIR under Section 482, and this court, while setting aside the judgment imposed therein and quashing that FIR, took the view that the applicants are to be protected against vexatious and unwarranted criminal prosecution and from unnecessarily being put through the rigors of an eventful trial. The protection against vexatious and unwanted prosecution and from being unnecessarily dragged through a trial by melting a criminal proceeding into oblivion, either through quashing a complaint, a FIR complaint, or by allowing an appeal against an order rejecting discharge, or by the other legally permissible route, as the circumstance may be. In the deserving cases, it is a duty cast on the High Courts. The High Court should have intervened and discharged the applicants, but this court will intervene, being the celestial to revive. The next two judgments are very important, small judgments, but few other things have been said by the court. Haji Iqbal 9 and 8, page number 113. This is 2023 SCC online, Supreme Court. From para 2 Lordship will find this was a case under section 376D and 506 and facts Lordship will get at page 3. Here also allegation was that the accused, the petitioner before the High Court and appellant before the Supreme Court had forced her to physical relations. And para 3 FIR is the information is directed here. Then para 12 and 14 are important. Here the Honorable Apex Court uses the words between the lines, para 12, page 11. We are of the view that in absence of any particular allegation in the FIR against the applicant herein, the High Court should not have declined to quash the FIR. Here also names of persons are given. No specific role is attributed to me in particular. I would say nothing has been said that
This
I
is
give.
para number?
Para 12, page number 119. We are of the view, may I read this?
Yes.
We are of the view that in the absence of any particular allegation in the FIR against the applicant herein, the High Court should not have declined to quash the FIR by way of a cryptic order, saying that the applicant has criminal antecedents, and the FIR prima facie reveals commission of cognizable offence. The High Court should have first inquired as to what type of allegation have been leveled against the applicant. By just naming the applicant in the FIR, offence cannot be said to have been committed by. If any particular role is attributed or some kind of active participation is alleged in relation to the alleged offence, then it would be a different scenario. Para 14 was at this stage, we would like to observe something important. Para 14. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either inherent powers under section 482 of the Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motive for reckoning vengeance, then in such circumstances the court owes a duty to look into the FIR with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for reckoning personal vengeance etc., then he would ensure that the FIR stroke complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offence. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredient to constitute the alleged offence are disclosed or not. In a frivolous or vexatious proceeding, the court owes a duty to look into many other tending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but it is empowered to take into account the overall circumstances leading to the initiation registration of the case as well as the materials collected in the course of investigation. Take for instance the case on hand, multiple FIRs have been registered over a period of time. It is in the background such circumstances the registration of multiple FIRs assumes importance, thereby attracting the issue of reckoning vengeance out of private or personal grudge as an instrument. Last Muller's judgment. Only paragraph Lordship may take note of. Plus, this is 2023 SSC online, page number 120. हजूरी लेडीशिप की पेज नंबर 5 जो है ना, ये शायद हमने इंडिकेट किया था लास्ट में सारे
उसको देख के निश्चिंत हो गए
जी
ये सब एक जगह है
जी। पहले शुरू में लगाना था, पीछे लगा था, हम उसको अलग से फ्लैग करके रखे इसीलिए कि हम ही ना भूल जाए।
हम लोग को बस एक ही चिंता रहता है कि कोई आपका आर्गुमेंट छूटना नहीं चाहिए।
नहीं, वो कभी
That
नहीं
is our
होता,
concern.
वो कभी नहीं होता। कई बार हम लोग से कुछ छूट जाता है, आपसे गलती नहीं होती। Let's kindly see page number 120.
120. Yes.
ये भी सेम बेंच का ही जजमेंट है। यहाँ 376 नहीं था, लेकिन सब था 386।
सेक्शन से नहीं डिसाइड होगा ना, प्रिंसिपल से
हाँ,
डिसाइड।
प्रिंसिपल्स पे मैंने एलिगेशंस,
बाकी वो 302 और
हाँ
376
एलिगेशन, जी
सबको लाना।
जी। इसका पैराग्राफ नंबर 13 देखा, at this stage. सेम पैसेज है, चूंकि सेम बेंच का जजमेंट है, सेम वाला पैसेज है. Now the last two judgments, 3 judgments are on. Well, my friend's argument had been that one of the persons had withdrawn. That was best.
अभी तो वो आर्गुमेंट शुरू कर,
नहीं
वो
हुजूर
एक वो शुरू कर लंगी जिसको बोलते हैं.
ने हजूर पूछे थे तो हम
आपसे भी हम पूछ लिए
हर
भाई आपका क्या मंशा है.
इसीलिए देखिए यहाँ से हम तीनों उसका जवाब है.
मैं भी वो
अब
जवाब
यही कह रहे हैं, बोला so far please second application can be filed. ये इस पे है 1975 volume 3 CC 706. Second application can be filed. बोला then Vinod Kumar versus Union of India, ये भी है. Second application can be filed after withdrawal also. So 482 मतलब does not restrict. We go by the language of 482. It does not restrict. It is the extraordinary power and the so at the last what you kindly see, मतलब this judgment in third case जो 2017
आपका
वाला
तो केस आया ही नहीं था पहले, तो आपके ऊपर वो सब somebody has withdrawn, how are you concerned with that?
correct
You are not concerned.
शुरू में बोली थी तो थोड़ा पहले ही हम तैयारी कर लिए. पेज 13 पे एक
इसलिए
जजमेंट
बोले थे क्योंकि कोई विड्रॉ कर लिया है तो आपका मंशा जानना चाहता
शायद कहीं मतलब पेज 13 देखा. जो तीसरा वाला केस था 2017 वाला, उसके बारे में कोट कर
पेज नंबर कौन सा है?
पेज 13 इसी कंपाइलेशन.
13.
हाँ इसी कंपाइलेशन में पेज नंबर 13 जो तीसरा वाला केस. As per the case of the complainant, on 8/8/2015, the petitioners are other office bearers of so and so with the local district administration forcibly entered into the premises of the said school and verbally abused the complainant and her husband to vacate the residential quarter. After the incidents, her husband immediately left the premises of the school and went to Ranchi, and the complainant continued to stay in the residential quarter of the school. On 9/8/2015, she was accosted by the accused persons and was constrained to leave her residential quarter from 3 p.m. to 7 p.m. in order to contact the police. When she returned after 8 p.m., she found some articles to be missing. ये केस था और इसी पे कोर्ट ने जाकर के मतलब पारा 9 में कहा है. तो 3 different versions lordship will find of the same incident और 8/8 का और 9/8 का. So these are the close cases apparently and other documents लगा हुआ है, उस पर हम मान लो उसको नहीं ले जा रहे हैं कि कैसे स्कूल का डिस्प्यूट हुआ, किस तरह से ये एक पे एक दिखाओ. हम एक चीज खाली दिखा देना चाहते हैं. गाड़ी जो इनेक्शन 9 खाली देख लिया. इनेक्शन 9 खाली देखा और कुछ नहीं. Section 9 page 93 of the सेवा में प्रचार महोदय लिख रही है खुद 9/8 निवेदन पूर्वक कहना है कि मैं धर्मशिला देवी पति सोयनसो भूतपूर्व प्रचार सोयनसो मंदिर चाईबासा हूँ. मेरे पति का चाईबासा स्कूल से अन्यत्र स्थानांतरण हो गया है. मेरे पति अभी चाईबासा से बाहर है, जिस कारण घर खाली करने में मुझे तकलीफ है. मुझे अभी वर्तमान में अपना कुछ कपड़ा तथा मेरा उजला रंग का स्कॉर्पियो गाड़ी जे सोयनसो को मुझे दे दिया जाए. इसके बाद 2-3 रोज बाद पुनः आकर अपना कपड़ा वगैरह ले जाऊंगी. किस तरह का कोताही नहीं बरतूंगी. और नीचे देखा मैं स्कॉर्पियो गाड़ी इतना प्राप्त किया. ले रही है, बाकायदे गाड़ी लेके गई है और स्कूल की गाड़ी आज तक नहीं लौटा. स्कूल का गाड़ी बाकी तो मतलब जो है सो एक चीज है क्लियर, इनके खुद के कंप्लेंट के मुताबिक police was there. We had approached the district administration for vacation of the premises and all because he was occupying forcefully. And after we approached the district administration, then the district, Malas kindly see page 94 in extra 10. ये देखा जाए नेक्स्ट 10 से हम लोग अप्रोच किए डीसी को कि हम ये है चिंतन की बैठक होने वाली है, सो नवीन प्रचार को देना है। देन देखा जाए नेक्स्ट 11 8 का ही है, मजिस्ट्रेट अपॉइंट हुए पेज नंबर 95 में, पेज 95 मुकेश नंदन स्वयंसो के द्वारा 8 को अपराह्न 3 बजे, समय वही है 3 बजे, नवीन समिति एवं नवीन प्राचार्य को विद्यालय प्रवेश एवं योगदान कराने एवं शांति व्यवस्था बनाए रखने हेतु उपायुक्त महोदय से अनुरोध किया गया। उपायुक्त महोदय के द्वारा कार्यक्रम के दौरान अनुमंडल पदाधिकारी को स्वयंसो दिया गया। तालुक में मुकेश मछुआ स्वयंसो को पद्मावती जैन स्वयंसो में दंडाधिकारी के रूप में प्रतिनियुक्त करते हुए सब पुलिस के और एडमिनिस्ट्रेशन के सामने हो। this much.
Yes, respondent.
May I take leave?
Lordship, trial is a general rule, quashing is an exception.
Sorry? Trial is on.
Trial is the general rule and quashing of the prosecution is exception. So whether this case comes under the category of exception or not, I will try to demonstrate that also.
Yes.
For quashing, the general rule is that, Lordship, that if the entire complaint is taken at its face value, if no offence is made out, it can be quashed. If the court is satisfied that from the contents of the FIR or complaint, any case is made out, then court will not embark upon the inquiry, any material, any document to quash the matter. For that purpose, the complaint has already been read out by my lord, but again, with the course of repetition, I want to just quote 2 paragraphs of the complaint petition also. Page 57. Paragraph 3. That on 9/8/2015 at about 11 am to 2 pm, all the named accused number 1 to 8 along with 10 to 12 unknown persons forcibly entered into her residential house in absence of husband and started abusing her in filthy languages, and they all made learned demand for sexual favors, and on denial they all on pistol point in the fear of instant death compelled her to write one application in the name of principal of said school and forced to write the text, as my husband has been transferred to elsewhere and due to his out of station, I am unable to vacate the allotted residential house in her husband's name, and I shall vacate the allotted house within 2-3 days. So kindly allow me to take my Scorpio vehicle with few dressing clothes to take out. It is pertinent to mention herein that the petitioner's husband has never been transferred by authorized and legal appointing authority, and as such, this application is nothing but force. The complainant under compel and in the fear of instant death left the allotted residential house on the same day at 5:10 p.m. and rushed to another residential house situated at Ranchi by said Scorpio car with driver. The complainant reached at 10:30 p.m. night on the same day at another residential house situated at court number section Dam side, Durbar Ranchi. On the same at 11 p.m. night, the named accused persons under serial number 1 to 8 and 10 to 12 unknown persons by chasing her from Chaibasa to Ranchi came at Ranchi and forcibly entered into her residential house armed with the deadly weapon and once again read off her blouse export and once again made attempt to tear off her dress sari with intention to observe a private part of picking MAS to expose the same amongst many persons, but somehow the complainant fled from the back door of the house and saved herself. So from the perusal of these paragraph 3 or 4, any offence is made out or not. Simultaneously, Lordship, she was examined by the magistrate under section 202 and has been annexed at page 53.
Yes, she must have supported her case.
So before the suing process, magistrate examines the complaint whether any prima facie case is made out or not.
That's so the process, that is the procedure.
Procedure, that is the procedure. So see,
My husband will file a case and then wife will file another case. This is their case.
there are two lots of incidents. One happened at Chaibasa, and this is the subsequent incident also. So for one part,
What is the date, time and place of occurrence so far as the first incident is concerned?
this incident took place on 9/8/15 also.
This took place on,
9/8/15.
this is related to 9/8/15
Lordship
at
at 11 p.m.
at 11 p.m. Place,
Place Ranchi.
which place? Home. Home. At her home.
At her home.
What about the other?
Other is Lordship 8/8/2015.
That is not the allegation here regarding 8. 8 तारीख का भी था 9/8.
This allegation is not at Ranchi Lordship. This is at Chaibasa.
Yes, 8/8/2015. It is at Chaibasa.
Lordship, my humble submission, there may be contradictions. Contradictions cannot form a basis for the quashing of the prosecution. They may be taken into consideration for the purpose of cross-examination, Lordship. My humble submission, Lordship, if the judgment of the two, I only two judgments, Lordship, not this one is Lordship, 2012 volume 9 SEC page 460. And another is Lordship, 1988 volume 4 SEC page 655. And it's Lordship, paragraph 15 of the judgment, 1988. Paragraph 15. Arising of the complaint is also. It is tried that jurisdiction under section 482 CRPC, which saves the inherent power of the High Court to make such orders as may be necessary to prevent abuse of the process of any court or otherwise to secure the ends of justice, has to be exercised sparingly and with circumspection. In exercising their jurisdiction, the High Court should not embark upon an inquiry whether the allegations in the complaint are likely to be established by evidence or not. That is the function of the trial magistrate when the evidence comes before him, though it is neither possible nor advisable to lay down any inflexible rules to regulate their jurisdiction. One thing, however, appears clear, and it is that when the High Court is called upon to exercise this jurisdiction to pass a proceeding at the stage of the magistrate taking cognizance of an offence, the High Court is guided by the allegations, whether those allegations set out in the complaint or the charge sheet do not in law constitute or spell out any offence, and that resort to criminal court. Same has been reiterated in Lordship 2012. And DC Lordship, page 465 of the report, सब पैरा 11 465 के ठीक बीच में है. Another very significant caution that the courts have to observe is that it cannot examine the facts, evidence, and materials on record to determine whether there is sufficient material on the basis of which the case would not end in a conviction. So my restricted argument is only restricted to the allegations made in the
What
complaint.
is the present stage of the case?
They have not appeared in the court below till date. Warrant of arrest has been issued according to my information.
State भी है इसमें. State is absent. Complaint है state का काम. Okay. CILP number 642 of 2016. Appearance दीजिए सबका. This petition has been filed for quashing the order dated 1/2016 along with the entire criminal proceedings passed in complaint case number 2102 of 2015 by the Court of Judicial Magistrate First Class, Ranchi, whereby cognizance has been taken for offence under section 354 within bracket B bracket close of Indian Penal Code against the petitioner and others. The learned counsel for the petitioner, while assailing the entire criminal proceedings, has submitted that the records of the case will reveal that the case arises out of malicious prosecution. He has submitted that there are repeated cases filed one after another relating to the same incident, and the present case has been filed by Dharamshila Devi, wife of Surendra Kumar Rai, and earlier case being complaint case number 111 of 2015 was filed against 20 persons, including the present petitioner.
23.
23 persons. Now with these लिखें. Note down.
The 20 were the officials of the schools and the RSS, and 3 were the officials.
Against 23 in which 23 persons were made opposite parties. Apart from that, it was also mentioned that there were 100 to 150 unknown persons. The learned counsel submits that the complaint case number 111 of 2015 has been ultimately quashed. It was sent for investigation by police and was numbered as DR case number 538 of 2015 and has been ultimately quashed by this court. In exercise of power under section 482 of CRPC. He has further submitted that the said complaint case was sent for investigation, and upon investigation it was final form was submitted, but the magistrate differed with the final form submitted by the police and took cognizance of offence under section 452, 454, 354, given by B, 387, 406, 420, 467, 468, 120B/34 of IPC. He has submitted that ultimately the court found that the entire allegation was ultimately the criminal case was quashed. From the perusal of the quashed in CRMP number 241 of 2017 on 5/4/2022. Upon perusal of the said order passed in CRMP number 241 of 2017, it is apparent that there were altogether 17 petitioners, in which the present petitioner was not a party. At this, counsel for the petitioner has submitted that after the order passed in CRMP number 241 of 2017 dated 5/4/2022, the criminal case has already been dropped. The learned counsel further submits that the present petitioner had filed another complaint case, which was complaint case number 426 of 2017. And the said complaint case has also been quashed by this court, and the entire proceeding, including summoning order, was quashed by the order dated 5/9/2023. The learned counsel submits that in the meantime, another case was filed by the opposite party number 2, which was complaint case number 2102 of 2015 against the petitioner and other accused persons. the husband of the complainant had filed the case being complaint case number 111 of 2015. And the same was registered as FIR number 91 of 2015. Which has ultimately been quashed in CRLP number 241 of 2017. The learned counsel submits that arising out of the same incident with slight different version, different cases have been filed. The other two cases have already been quashed by this court. And the present case has been filed with a malified intent, and it is a clear case of malicious prosecution, inasmuch as for the same set of, for almost similar set of allegations, with little difference, the opposite party number 2 has been filing cases either through herself or through her husband. The learned counsel submits that essentially the dispute is in connection with one school, and the opposite party number 2 is acting in a malicious manner and filing criminal cases, giving the dispute a criminal color. The learned counsel has referred to the various cases, has referred to the 3 cases which arises out of the, and claims that they arise out of the same incident. The learned counsel has relied upon following judgments. One है यहाँ पर reported in bracket 1988 bracket close 1 is CC 692 para 7. Then number 2 is bracket 2002 bracket close 3 SCC para page 89 para 6 and 8. Then 2022 SCC online Delhi 245 para 13, 14 and 15. And submits that these judgments deal with the general principle of law with regard to quashing of criminal cases. We have submitted that the celebrated judgment of State of Haryana versus Bhajan Lal has been consistently followed, and it has been held that in an appropriate case falling under one or the other category mentioned therein, it is the duty of the High Court to exercise power under section 482 of CRPC to quash the criminal proceedings, to prevent the abuse of the process of law. He has also submitted that in a case of malicious prosecution, there is no point saying that the person should face the trial and get acquittal. He has also submitted that there is no point saying that the matter has to be considered at the stage of discharge. The learned counsel has submitted that on the face of the allegations made in the 3 complaint petitions, it is apparent that it is almost similar allegations for which 3 different cases have been filed one after another, only to harass the petitioner. The learned counsel thereafter has referred to the judgment passed by the Honorable Supreme Court, reported in bracket 2020 bracket 13 SCC 435 paragraph 10 to 16, and submits that the said judgment specifically deals with case of malicious prosecution. The learned counsel further referred to the judgment reported in 2023 SCC online 1582 para 23 semicolon 2023 SCC online 948 and 2023 SCC online 950 to submit that para 13 to submit that it is the duty of the court to protect its citizens from vexatious proceedings. The learned counsel submits that, considering the totality of facts and circumstances of this case, the entire criminal proceedings, including order taking cognizance, be set aside. यही आपका submission? The learned counsel, appearing on behalf of opposite party number 2, the complainant, has submitted that at the stage of challenge to order taking cognizance, the allegations made in the complaint and the inquiry witnesses is required to be taken into consideration. He has also submitted that so far as the complainant is concerned, the present case is the only case which was filed by her. एक ही case filed हुआ और कोई दूसरा कोई नहीं है उनका?
Two minutes, that was quest of the
Not by the wife.
Not by the wife.
Why the wife? Supplement they have filed.
And the facts may be blocked.
426.
That is requesting, that is also request.
426.
Not 426, it is not the. Yes, yes, the case number is 426. But page 13 will be seen because the complainant was Dharmsila, the wife.
677 में ना?
I'm not CRM.
677 में squash हुआ है ना?
426 also not.
No, 426.
CRMP कौन सा?
CRMP है
2119.
119.
That is the of the
Compilation.
compilation का पेज नंबर 13 है.
इसमें कितना नहीं है इसमें? It's not.
कंप्लेंट है, कंप्लेंट लेक्चर है, ऑर्डर किस है?
इसमें election है.
हाँ,
कितना है?
पेज नंबर 13 कंपाइलेशन का CRMP नंबर 2119/2022 ऑर्डर डेटेड 5/9/2023 सेम एलिगेशन. Your paragraph 2, the complainant is the wife of Surinder Kumar.
That's it. That's it.
Same fact was there.
The
379 IPC.
ये बात नहीं है, ठीक है? The learned counsel submits that so far as the complaint case number 426 of 2017 filed by the opposite party number 2 is concerned, the same was lodged for offence under section 379 IPC and has been quashed in CRMP number 2119 of 2022. But in the said case, the present petitioner is not a party.
That was against others. But
And the
still
said case was not lodged against the present petitioner.
that was not lodged against the present petitioner, but the
We will record.
prosecution case is same.
With respect to the another complaint case, the learned counsel submits that, which was numbered as GR case number 538 of 2015. The learned counsel submits that the said case was quashed by this court in CRMP number 241 of 2017, in which the husband of the present complainant was the complainant. In the said case, the present petitioner was an accused, but he is not a party in CRMP number 241 of 2017. The learned counsel has further submitted that the filing of cases the learned counsel has further submitted that the complainant of the present case is required to be cross-examined with respect to the allegations made in the other complaint case, and the allegations made in the other complaint cases are not identical. He has referred to judgment passed by the Honorable Supreme Court reported in bracket 2012 bracket close 9 SCC 460. इसका पैराग्राफ क्या है? And bracket 1988 bracket close 4 SCC 655 para 15. He has submitted that there are serious allegations made against the petitioner, and the complaint case may not be quashed. He has also submitted that the petitioners have not even appeared before the learned court, and the matter has remained pending before this court since 2016. Anticipatory bail भी नहीं लिया है क्या? कुछ भी नहीं है.
We have not received any warrant or any summons. They are saying so. We will go, but if we will receive summons or anything.
In response, the counsel for the petitioner has submitted that
And because it was stayed, therefore nothing has been issued.
there was an interim order in favor of the petitioner, and therefore there was no occasion for the petitioner to go and participate in the proceedings. He submits that the present case is a fit case for quashing of the entire criminal proceedings to prevent the abuse of process of law at the hand of opposite party number 2. यही हो गया? Arguments concluded. January का first day बने.
I beg my lord's pardon regarding second complaint notice. There is no whisper in the quashing application. Therefore, I had no knowledge about that. Therefore, I
Lord, that is subsequently it was quashed and no
What
whisper
was
and whisper. Lord, when it has been subsequently quashed, how can we will the complete this CRMP was filed in the year 2016.
Complaint तो पहले फाइल हुआ.
जी कंप्लेंट पहले फाइल हुआ है उसमें भी तो उन्होंने इस मतलब नहीं हमारा इनका जो कहना है this order will not kindly see how we will whisper not kindly see when this order was passed. This was passed on 5/9/2023. So how we will bring this in the our CRM?
Complaint किसका हुआ?
Complaint case was filed in the year 2017. It is pleaded, but we have filed supplementary affidavit. How can we bring this order in the?
Supplementary affidavit
Yes,
में डाल दिया.
supplementary है डाला हुआ है.
Supplementary में डाला हुआ.
दिखा दीजिए.
Second.
ले लीजिए सर supplementary.
online.
अभी दे दीजिए. नहीं supplementary filed है देखिए.
Assault case item 2. WPL
केस नंबर को लेके कोई कंफ्यूजन होगा तो पूछेंगे क्योंकि कंप्लेंट केस चला जाता है एफआईआर में फिर कभी-कभी मैच नहीं हो पाता. ठीक है. एक चार्ट बना के दे देंगे तो इजी होगा.
बिल्कुल.
है ना. जितने भी केसेस है किसने फाइल किया है और उसका कॉरेस्पॉन्डिंग बीआर को
डेट क्या है उसका कॉरेस्पॉन्डिंग डेट क्या है और
हाँ, ये
क्या है वैसे भी
हम उसको ऑर्डर में ही इनकॉर्पोरेट.
जी.
Yes, have you?
Assault case item 2.
आपकी क्या
WPL
case है?
6.
Little date खाली नहीं है.
ठीक है.
उनके पास भी नहीं. Both petitioner discharge order 10 and 13, so I have written the petition number 1 on 10 and petition number 2 on 13.
देखिए WPL number 6656 of 2006. For the learned counsel for the parties. This petition has been filed challenging the order dated 18/1/2006 passed by learned presiding officer Labor Court Jamshedpur in NJ case number 16 of 1998. Whereby the petitioner was directed to pay to the concerned workman amount of wages towards amount of wages equivalent to yearly increment with VDA for the period of 27 years after fitment of wages year-wise, fixed annual bonus at the rate of 8.33% and pay earned leave equivalent to wage of 182 days and 6 leave travelling concession allowance. The said amount has been directed to be paid with interest at the rate of 6%. The petitioner has been directed to calculate the amount and pay the same. The learned counsel for the petitioner, while giving the background of the case, has submitted that the present case involves only two workmen, namely Krishna Kumar Krishna Murmu and Mrinal Das Gupta. Both of them have expired and are represented before this court through their legal heir/successor.
In fact, Lord, the Mrinal Das Gupta had died prior to filing. Right?
The learned counsel submits that 9 persons, including the aforesaid 2 employees, were employed by the petitioner, and on some charges of criminal conspiracy they were arrested, and ultimately their services were terminated. So far as Krishna Kumar Murmu and Mrinal Das Gupta and one another employee is concerned, they were simpliciter discharged from service. All the 9 workmen, they challenged their order of termination, and a reference case number 1 of 1974 was instituted before the Labour Contempt Court. The award was passed on 13/7/77, wherein it was held that discharge of 5 employees, including Krishna Kumar Murmu and Mrinal Das Gupta, was justified. Hence, there was no order of reinstatement for them. A writ petition being CWJC number 38 of 1978 (R) was filed by the petitioner challenging that part of the award dated 13/7/77, whereby discharge of 4 employees was held to be invalid. And were directed to be reinstated with back wages. And further, those 5 remaining workmen whose discharge was held to be justified in terms of the award dated 13/7/77 also filed with petition being CWJC number 140 of 1978 (R). Both the writ petitions were ultimately disposed of by this court in by judgment and order dated 21/1/1983. CWJC, whereby CWJC number 38 of 1978 (R) and disposed of by order dated 21/1/1983. Consequently, Mrinal Das Gupta and Krishna Kumar Murmu Kumar Krishna Murmu, along with 2 others, were directed to be reinstated with back wages from the dates their services were terminated. The order passed by the writ court has been placed on record in the supplementary affidavit.
Annexure 10, supplementary affidavit.
In the supplementary affidavit by the annexure 10. The matter was taken up before the Honorable Supreme Court by the petitioner and the special leave petition was dismissed by the order dated, was ultimately dismissed. And in terms of order dated 2985, a direction was issued. It was ultimately dismissed. It was dismissed in terms of order dated 2/9/1985, within bracket annexure 1. It was directed that the entire amount due as arrear of salary shall be deposited. ये interim order था क्या?
ये interim order. By the annexure 2,
Was dismissed by the annexure 2. Annexure 2. The learned counsel submits that thereafter the entire admissible dues was paid to both the aforesaid workmen. एक ही का सिर्फ आप लगाएं के मुर्मू का, दूसरे का नहीं लगाया ना.
So during service he met an accident and
accident नहीं
accident he died during his service period.
It has been submitted that as per the final order passed by the Honorable Supreme Court dated 16/7/1996, Shri Kumar Krishna Murmu joined duty and Shri Mrinal Das Gupta also joined duty on 23/10/1996.
Krishna Murmu reinstated on 8/10 in 1986. So 96. And Mrinal Das Gupta on 16/10/96.
ये तो रिट पिटीशन में जो लिखा है गलत लिखा है क्या? कहाँ से पढ़ रहे हैं? से पढ़ रहे हैं. Is there any error in the repetition? Para 16 and 17? And Mrinal Dasgupta died on 30/10/1996.
सही है मतलब ये एक्सीडेंट हुआ था इसका.
It is submitted that thereafter, on or about 30/7/1998, a petition was filed under section 33(c)(2) of the Industrial Disputes Act, read with section 29 thereof. Claiming certain amount relating to back wages and interest thereon. The list of claims have been enlisted in paragraph 18 of the writ petition, which is also apparent from annexure 4 to the writ petition, which is the petition filed by the concerned workman. The case was numbered as NJ case number 16 of 1998. He submits that a show cause was filed on behalf of the petitioner denying the liability to make any further amount over and above what was already paid. The learned counsel submits that, in spite of the fact that the petitioner had disputed the liability to pay the amount as claimed, the learned labour court passed the impugned order directing payment of the aforesaid payment on account of aforesaid heads. She has also submitted that the denial was item wise and by citing reasons. The reasons for denial has been mentioned in the show cause filed by the petitioner as contained in annexure 5. The learned counsel submits that once the liability is disputed, there was no occasion for the learned court to pass the order under section 33(c)(2), as the liability itself requires adjudication. She has also submitted that the learned labour court has not even quantified the claim. Rather, the concerned workmen never filed any computation, and the labour court has left the computation to be done by the petitioner, although the petitioner has paid the entire amount as per their own calculation and understanding under different heads. The learned counsel has submitted that there was a direction to pay back wages, but what would go into the computation of back wages was still required to be adjudicated. Correct? यही है आपका? And therefore the petition under section 33C2 was fit to be dismissed, and unless the entitlement under each head is not decided, the computation could not have been made under section 33C2. The learned counsel appearing on behalf of the respondent while opposing the prayer has submitted that the heads under which the claim was made was admissible, and the reasons shown to deny the liability was not tenable in the eyes of law, and accordingly the learned court has rightly passed order under section 33C2. He has further submitted that direction to pay back wages would include all the components which form part of the back wages, and the components were in terms of the service rules governing the workmen. He has submitted that there is no illegality or perversity in the impugned order calling for any interference by this court in writ jurisdiction. That's all.
Was an order of restatement with full back wages has been passed, then other benefits which is
The
petitioners
learned
are
counsel has
impacted
also submitted
automatically
that
comes into force.
once an order for reinstatement with back wages has been passed, the benefits which has been granted to the petitioner by the impugned order automatically flows from the same,
Yes.
and there is no requirement to have a separate adjudication on the entitlement of the concerned workmen by entering into another industrial dispute. It was only a matter of computation and nothing more. Denial for the sake of denial is no denial in the eyes of law. यही है? हमको जाना आज थोड़ा मीटिंग.
ठीक है.
We'll continue tomorrow. इसको टाइप कर लेना. क्या है?
Land acquisition का representation was
Serial time.
ठीक. सीरियल टाइप कर.